Justice Stevens dissenting, in District of Columbia v. Heller, 554 U.S. 2008 slip-up at 1. The court answered the question whether a federal enclave's prohibition on the possession of usable handguns in the home violates the Second Amendment to the Constitution. The question we should be answering in this case is whether the Constitution guarantees individuals' fundamental right to enforceable against the states to possess functional personal firearm, including handgun, within the home. A complaint PAP 23 that is different and more difficult inquiry than asking if the 14th Amendment incorporates the Second Amendment. The so-called incorporation question was squarely and, in my view, correctly resolved in the late 19th century. Footnote 1. Before the district court, petitioners focused their pleadings on the special considerations raised by domestic possession, which they identified as the core of their asserted right. In support of their claim that the city of Chicago's handgun ban violates the Constitution, they now rely primarily on the Privileges or Immunities Clause of the 14th Amendment. See brief for Petitioners 965. They rely secondarily on the Due Process Clause of that amendment. CID at 6672. Neither submission requires the court to express an opinion on whether the 14th Amendment places any limit on the power of states to regulate possession, use, or carriage of firearms outside the home. I agree with the plurality's refusal to accept petitioner's primary submission. Ante at 10. Their briefs marshal an impressive amount of historical evidence for their argument that the court interpreted the Privileges or Immunities Clause too narrowly in the Slaughterhouse cases, 16 Wall, 36, 1873. That the original meaning of the clause is not as clear as they suggest. Footnote 2. And not nearly as clear as it would need to be to dislodge 137 years of precedent. The burden is severe for those who seek radical change in such an established body of constitutional doctrine. Footnote 3. Moreover, the suggestion that invigorating the Privileges or Immunities Clause will reduce judicial discretion, see reply brief for petition 22 N. 826, or of oral arg. 6465, strikes me as implausible, if not exactly backwards, for the very reason that it has so long remained clean slate. Revitalized Privileges or Immunities Clause holds special hazards for judges who are mindful that their proper task is not to write their personal views of appropriate public policy into the Constitution. Footnote 4. I further agree with the plurality that there are weighty arguments supporting petitioner's second submission insofar as it concerns the possession of firearms for lawful self-defense in the home, but these arguments are less compelling than the plurality suggests. They are much less compelling when applied outside the home, and their validity does not depend on the court's holding in Heller, for that holding sheds no light on the meaning of the Due Process Clause of the 14th Amendment. Our decisions construing that clause to render various procedural guarantees in the Bill of Rights enforceable against the states likewise tell us little about the meaning of the word liberty in the clause or about the scope of its protection of non-procedural rights. This is substantive due process case. Section 1 of the 14th Amendment decrees that no state shall deprive any person of life, liberty, or property without due process of law. The court has filled thousands of pages expounding that spare text. As I read the vast corpus of substantive due process opinions, they confirm several important principles that ought to guide our resolution of this case. The principal opinions lengthy summary of our incorporation on doctrine, CNT 9/11-19 majority opinion, 10/11 plurality opinion, and its implicit and untenable effort to wall off that doctrine from the rest of our substantive due process jurisprudence invite fresh survey of this old terrain. Substantive content. The first and most basic principle established by our cases is that the rights protected by the Due Process Clause are not merely procedural in nature. At first glance, this proposition might seem surprising given that the clause refers to process, but substance and procedure are often deeply entwined. Upon closer inspection, the text can be read to impose nothing less than an obligation to give substantive content to the words liberty and due process of law. Washington v. Klucksberg 521 U.S. 702-764 1997 Souter J. Concurring in judgment lest superficially fair procedures be permitted to destroy the enjoyment of life, liberty, and property. Poe v. Ullman 367 U.S. 497 541 1961 Harlan J. Dissenting in the clause's prepositional modifier be permitted to swallow its primary command. Procedural guarantees are hollow unless linked to substantive interests, and no amount of process can legitimize some deprivations. I have yet to see persuasive argument that the framers of the 14th Amendment thought otherwise. To the contrary, the historical evidence suggests that, at least by the time of the Civil War if not much earlier, the phrase Due process of law had acquired substantive content as term of art within the legal community. Footnote 5. This understanding is consonant with the venerable notion that governmental authority has implied limits which preserve private autonomy. Footnote 6. Notion which predates the founding and which finds reinforcement in Constitution's Ninth Amendment. See Griswold v. Connecticut, 381 U.S. 479, 486, 493, 1965. Goldberg, J. Concurring. Footnote 7. The Due Process Clause cannot claim to be the source of our basic freedoms. No legal document ever could. See Meacham v. Fano, 427 U.S. 215, 230, 1976. Stevens, J. Dissenting. But it stands as one of their foundational guarantors in our law. If text and history are inconclusive on this point, our precedent leaves no doubt. It has been settled for well over a century that the Due Process Clause applies to matters of substantive law as well as to matters of procedure. Whitney v. California, 274 U.S. 357, 373, 1927. Brandeis, J. Concurring. Time and again, we have recognized that in the 14th Amendment as well as the 5th, the Due Process Clause guarantees more than fair process, and the liberty it protects includes more than the absence of physical restraint. Glucksberg, 521 U.S. at 719. The clause also includes substantive component that it provides heightened protection against government interference with certain fundamental rights and liberty interests. Troxel v. Granville, 530 U.S. 57, 65, 2000. Opinion of O'Connor, J. Joined by Rehnquist, C. J. and Ginsburg and Breyer, J.J. Quoting Glucksberg, 521 U.S. at 720. Some of our most enduring precedents, accepted today by virtually everyone, were substantive due process decisions. C. E. G. Loving v. Virginia, 388 U.S. 112, 1967, recognizing due process, as well as equal protection-based right to marry person of another race. Balling v. Sharp, 347 U.S. 497, 499, 500. 1954, outlawing racial segregation in District of Columbia Public Schools. Pierce v. Society of Sisters, 268 U.S. 510, 534, 535, 1925, vindicating right of parents to direct upbringing and education of their children. Mayer v. Nebraska, 262 U.S. 390, 399, 403, 1923, striking down prohibition on teaching of foreign languages. Liberty. The second principle woven through our cases is that substantive due process is fundamentally a matter of personal liberty, for it is the Liberty Clause of the 14th Amendment that grounds our most important holdings in this field. It is the Liberty Clause that enacts the Constitution's promise, measure of dignity and self-rule will be afforded to all persons. Planned Parenthood of Southeastern Pa. v. Casey, 505 U.S. 833, 847, 1992. It is the Liberty Clause that reflects and renews the origins of the American heritage of freedom and the abiding interest in individual liberty that makes certain state intrusions on the citizen's right to decide how he will live his own life intolerable. Fitzgerald v. Porter Memorial Hospital, 523 F. Twad 716, 700, Ha 1975, Stevens, J. Our substantive due process cases have episodically invoked values such as privacy and equality as well, values that in certain contexts may intersect with or complement subjects' liberty interests in profound ways. But as I have observed on numerous occasions, most of the significant 20th century cases raising Bill of Rights issues have, in the final analysis, actually interpreted the word liberty in the 14th Amendment. Footnote 8, it follows that the term incorporation, like the term unenumerated rights, is something of misnomer. Whether an asserted substantive due process interest is explicitly named in one of the first 8 amendments to the Constitution or is not mentioned, the underlying inquiry is the same. We must ask whether the interest is comprised within the term liberty. Whitney, 274 U.S. 373. Brandeis, J. Concurring. As the second, Justice Harlan has shown, ever since the court began considering the applicability of the Bill of Rights to the states, the court's usual approach has been to ground the prohibitions against state action squarely on due process without intermediate reliance on any of the first 8 amendments. Malloy v. Hogan, 378 U.S. 124, 1964, dissenting opinion. See also Frankfurter Memorandum on Incorporation of the Bill of Rights into the Due Process Clause of the 14th Amendment 78 Harv. L. Everett 746, 747, 750, 1965. In the pathmarking case of Gitlow v. New York 268 U.S. 652, 666, 1925, for example, both the majority and dissent evaluated petitioners' free speech claim not under the First Amendment but as an aspect of the fundamental personal rights and liberties protected by the Due Process Clause of the 14th Amendment from impairment by the states. Footnote 9, in his own classic opinion, in Griswold 381 U.S. that 500 concurring in judgment, Justice Harlan memorably distilled these precedents lesson. While the relevant inquiry may be aided by resort to one or more of the provisions of the Bill of Rights, it is not dependent on them or any of their radiations. The Due Process Clause of the 14th Amendment stands on its own bottom. Footnote 10, inclusion in the Bill of Rights is neither necessary nor sufficient for an interest to be judicially enforceable under the 14th Amendment. This Court's selective incorporation doctrine ante at 15 is not simply related to substantive due process ante at 19. It is subset thereof. Federal-state divergence. The third precept to emerge from our case law flows from the second. The rights protected against state infringement by the 14th Amendment's Due Process Clause need not be identical in shape or scope to the rights protected against federal government infringement by the various provisions of the Bill of Rights. As drafted, the Bill of Rights directly constrained only the federal government. See Baron X. Rel. Tiernan v. Mayor of Baltimore, 7 243, 1833. Although the enactment of the 14th Amendment altered our legal order, it did not unstitch the basic Federalist pattern woven into our constitutional fabric. Williams v. Florida, 399 U.S. 78, 133, 1970, Harlan J., concurring in result. Nor, for that matter, did it expressly alter the Bill of Rights. The Constitution still envisions a system of divided sovereignty, still establishes federal republic where local differences are to be cherished as elements of liberty. In the vast run of cases, National Rifle Assen of Inc. v. Chicago 567 F. 3 856 860 Ca. 2009 Easterbrook C. J. still allocates a general police power to the states in the states alone. United States v. Comstock 560 U.S. 2010 Slip-Up at 4 Kennedy J. concurring in judgment. Elementary considerations of constitutional text and structure suggest there may be legitimate reasons to hold state governments to different standards than the federal government in certain areas. Footnote 11, it is true, as the Court emphasizes ante at 1519, that we have made numerous provisions of the Bill of Rights fully applicable to the states. It is settled, for instance, that the governor of Alabama has no more power than the President of the United States to authorize unreasonable searches and seizures. Curvey, California, 374 U.S. 23, 1963. But we have never accepted a total incorporation theory of the 14th Amendment, whereby the amendment is deemed to subsume the provisions of the Bill of Rights en masse, see ante at 15, and we have declined to apply several provisions to the states in any measure, see e.g. Minneapolis and St. Louis R. Company v. Bomballis 241 U.S. 211, 1916 7th Amendment, Hurtado v. California, 110 U.S. 516, 1884, Grand Jury Clause. We have, moreover, resisted uniform approach to the Sixth Amendment's criminal jury guarantee, demanding 12-member panels and unanimous verdicts in federal trials, yet not in state trials. See Apodaca v. Oregon, 406 U.S. 404, 1972, Plurality Opinion Williams 399 U.S. 78. In recent years, the Court has repeatedly declined to grant certiorari to review that disparity. Footnote 12, while those denials have no precedential significance, they confirm the proposition that the incorporation of provision of the Bill of Rights into the 14th Amendment does not, in itself, mean the provision must have precisely the same meaning in both contexts. It is true, as well, that during the 1960s the Court decided a number of involving procedural rights in which it treated the Due Process Clause as if it transplanted language from the Bill of Rights into the 14th Amendment. C.E.G. Benton v. Maryland 395 U.S. 784, 795, 1969, Double Jeopardy Clause. The Pointer v. Texas 380 S. 400 406 1965 Confrontation Clause. Jot for jot incorporation was the norm in this expansionary era, yet at least one subsequent opinion suggests that these precedents require perfect state-federal congruence only on matters at the core of the relevant constitutional guarantee. Christ v. Bretz 437 U.S. 2837, 1978. See also ID. At 5253 Powell J. Dissenting. In my judgment, this line of cases is best understood as having concluded that, to ensure a criminal trial satisfies essential standards of fairness, some procedure should be the same in state and federal courts. The need for certainty and uniformity is more pressing, and the margin for error slimmer when criminal justice is at issue. Principle has little relevance to the question whether non-procedural rule set forth in the Bill of Rights qualifies as an aspect of the liberty protected by the 14th Amendment. Notwithstanding some overheated dicta in Malloy, 378 U.S. that 1011, it is therefore an overstatement to say that the court has abandoned ante at 1617 majority opinion 39 plurality opinion two-track approach to incorporation ante at 37 plurality opinion. The court moved away from that approach in the area of criminal procedure, but the Second Amendment differs in fundamental respects from its neighboring provisions in the Bill of Rights, as I shall explain in part the infra, and if some 1960s opinions purported to establish general method of incorporation, that hardly binds us in this case. The court has not hesitated to cut back on perceived Warren Court excesses in more areas than I can count. I do not mean to deny that there can be significant practical, as well as aesthetic benefits from treating rights symmetrically with regard to the state and federal governments. Jot-for-jot incorporation of provision may entail greater protection of the right at issue and therefore greater freedom for those who hold it. Jot-for-jot incorporation may also yield greater clarity about the contours of the legal rule. See Johnson v. Louisiana, 106 U.S. 356, 384, 388, 1972, Douglas, J. Dissenting and Pointer, 380 U.S. of 413, 414, Goldberg, J. Concurring. In federalist systems such as ours, however, this approach can carry substantial costs. When federal court insists that state and local authorities follow its dictates on matter not critical to personal liberty or procedural justice, the latter may be prevented from engaging in the kind of beneficent experimentation in things social and economic that ultimately redound to the benefit of all Americans. New State Ice Company v. Liebman, 285 U.S. 262, 311, 1932, Brandeis, J. Dissenting. The costs of federal courts imposing uniform national standard may be especially high when the relevant regulatory interests vary significantly across localities and when the ruling implicates the state's core police powers. Furthermore, there is real risk that, by demanding the provisions of the Bill of Rights apply identically to the states, federal courts will cause those provisions to be watered down in the needless pursuit of uniformity. Duncan v. Louisiana, 391 U.S. 145, 182, N. 21, 1968, Harlan J. Dissenting. When one legal standard must prevail across dozens of jurisdictions with disparate needs and customs, courts will often settle on relaxed standard. This watering down risk is particularly acute when we move beyond the narrow realm of criminal procedure and into the relatively vast domain of substantive rights. So long as the requirement, fundamental fairness are always and everywhere respected, it is not clear that greater liberty results from the jot-for-jot application of provision of the Bill of Rights to the states. Indeed, it is far from clear that proponents of an individual right to keep and bear arms ought to celebrate today's decision. Footnote 13. So far I have explained that substantive due process analysis generally requires us to consider the term liberty in the 14th Amendment, and that this inquiry may be informed by but does not depend upon the content of the Bill of Rights. How should court go about the analysis then? Our precedents have established not an exact methodology, but rather framework for decision-making. In this respect, too, the court's narrative fails to capture the continuity and flexibility in our doctrine. The basic inquiry was described by Justice Cardozo more than 70 years ago. When confronted with a substantive due process claim, we must ask whether the allegedly unlawful practice violates values implicit in the concept of ordered liberty. Palco v. Connecticut, 302 U.S. 319, 325, 1937. Footnote 14. If the practice in question lacks any oppressive and arbitrary character, if judicial enforcement of the asserted right would not materially contribute to fair and enlightened system of justice, then the claim is unsuitable for substantive due process protection, ID, at 327, 325. Implicit in Justice Cardozo's test, recognition that the postulates of liberty have universal character. Liberty claims that are inseparable from the customs that prevail in certain region, the idiosyncratic expectations of certain group, or the personal preferences of their champions may be valid claims in some sense, but they are not of constitutional stature. Whether conceptualized as rational continuum of legal precepts, Po 367 U.S. that 543, Harlan J. Dissenting or seamless web of moral commitments, the rights embraced by the Liberty Clause transcend the local and the particular. Justice Cardozo's test undeniably requires judges to apply their own reasoned judgment, but that does not mean it involves an exercise in abstract philosophy. In addition to other constraints I will soon discuss, see Peroman Threnfra historical and empirical data of ver. Heinz Graum the analysis, textual commitments laid down elsewhere in the Constitution, judicial precedents, English common law, legislative and social facts, scientific and professional developments, practices of other civilized societies, footnote 15, and above all else the traditions and conscience of our people, Balco 302 U.S. at 325, quoting Snyder v. Massachusetts 291 U.S. 97, 105, 1934 are critical variables. They can provide evidence about which rights really are vital to ordered liberty as well as a spur to judicial action. The court errs both in its interpretation of Palco and in its suggestion that later cases rendered Palco's methodology defunct. Echoing Duncan, the court advises that Justice Cardozo's test will not be satisfied. If civilized system could be imagined that would not accord the particular protection. Ante at 12, quoting 391 U.S. at 149 N. 14. Palco does contain some language that could be read to set an inordinate bar to substantive due process recognition, reserving it for practices without which neither liberty nor justice would exist. 302 U.S. 326. But in view of Justice Cardozo's broader analysis as well as the numerous cases that have upheld liberty claims under the Palco standard, such readings are plainly overreadings. We have never applied Palco in such draconian manner, nor, as the court intimates, Ante at 16, did Duncan mark an irreparable break from Palco, swapping out liberty for history. Duncan limited its discussion to procedural safeguard S in the Bill of Rights relating to criminal processes, 391 U.S. at 149 N. 14. It did not purport to set standard for other types of liberty interests. Even with regard to procedural safeguards, Duncan did not jettison the Palco test so much as refine it. The judge is still tasked with evaluating whether practice is fundamental to ordered liberty within the context of the Anglo-American system. Duncan 391 U.S. at 149 150 N. 14. Several of our most important recent decisions confirm the proposition that substantive due process analysis, from which, once again, incorporation analysis derives, must not be wholly backward-looking. C. E. G. Lawrence v. Texas 539 U.S. 558 572, 2003. H. History and tradition are the starting point but not in all cases the ending point of the substantive due process inquiry. Internal quotation marks omitted. Michael H. v. Gerald D. 491 U.S. 110, 127 128 and 6 1989, garnering only 2 votes for history-driven methodology that consult as the most specific tradition available. See also post at 6-7 Brer J. Dissenting, explaining that post-Duncan, the incorporation cases continue to rely on more than history. Footnote 16. The court's flight from Palco leaves its analysis, and scholarly though it is, much too narrow to provide satisfying answer to this case. The court hinges its entire decision on one mode of intellectual history, culling selected pronouncements and enactments from the 18th and 19th centuries to ascertain what Americans thought about firearms. Relying on Duncan and Glucksberg, the plurality suggests that only interests that have proved fundamental from an American perspective with Ante at 3744 or deeply rooted in this nation's history and tradition. Ante at 19, quoting Glucksberg 521 U.S. at 721, to the court's satisfaction may qualify for incorporation into the 14th Amendment, to the extent the court's opinion could be read to imply that the historical pedigree of right is the exclusive or dispositive determinant of its status under the Due Process Clause. The opinion is seriously mistaken. A rigid historical test is inappropriate in this case, most basically because our substantive due process doctrine has never evaluated substantive rights in purely or even predominantly historical terms. When the court applied many of the procedural guarantees in the Bill of Rights to the states in the 1960s, it often asked whether the guarantee in question was fundamental in the context of the criminal processes maintained by the American states. Footnote 17, Duncan, 391 U.S. the 150 N. 14. That inquiry could extend back through time, but it was focused not so much on historical conceptions of the guarantee as on its functional significance within the state's regimes. This contextualized approach made sense as the choice to employ any given trial-type procedure means little in the abstract. It is only by inquiring into how that procedure intermeshes with other procedures and practices in criminal system that its relationship to liberty and due process can be determined. Yet when the court has used a due process clause to recognize rights distinct from the trial context rights relating to the primary conduct of free individuals, Justice Cardozo's test has been our guide. The right to free speech, for instance, has been safeguarded from state infringement not because the states have always honored it, but because it is essential to a free government and to the maintenance of democratic institutions. That is because the right to free speech is implicit in the concept of ordered liberty. Thornhill v. Alabama, 310 U.S. 8895 96 1940. See also E. G. Loving, 380 U.S. at 12. Discussing right to marry person of another race. The Map v. Ohio, 367 U.S. 643, 650, 655, 657, 1961. Discussing right to be free from arbitrary intrusion by police. Schneider v. State, Town of Irvington, 308 U.S. 147, 161, 1939. Discussing right to distribute printed matter. Footnote 18. While the verbal formula has varied, the court has largely been consistent in its liberty-based approach to substantive interests outside of the adjudicatory system. As the question before us indisputably concerns such an interest, the answer cannot be found in a granular inspection of state constitutions, congressional debates. More fundamentally, a rigid historical methodology is unfaithful to the Constitution's command. For if it were really the case that the 14th Amendment's guarantee of liberty embraces only those rights so rooted in our history, tradition, and practice as to require special protection, what Glucksberg 521 U.S. at 721 N. 17, then the guarantee would serve little function save to ratify those rights that state actors have already been according the most extensive protection. Footnote 19 cf. Duncan 391 U.S. at 183 Harlan J. Dissenting critiquing circularity of historicized test for incorporation. That approach is unfaithful to the expansive principle Americans laid down when they ratified the 14th Amendment and to the level of generality they chose when they crafted its language. It promises an objectivity it cannot deliver and masks the value judgments that pervade any analysis of what customs defined in what manner are sufficiently rooted. It countenances the most revolting injustices in the name of continuity. Footnote 20. For we never forget that not only slavery but also the subjugation of women and other rank forms of discrimination are part of our history, and it effaces this court's distinctive role in saying what the law is, leaving the development and safekeeping of liberty to majoritarian political processes. It is judicial abdication in the guise of judicial modesty. No, the liberty safeguarded by the 14th Amendment is not merely preservative in nature but rather a dynamic concept. Stevens, The Bill of Rights, Century of Progress, 59 U. Chio. Everett 1338 1972. Its dynamism provides central means through which the framers enabled the Constitution to endure for ages to come. McCulloch v. Maryland, Forweed, 316 415 1819. Central example of how they wisely spoke in general language and left to succeeding generations the task of applying that language to the unceasingly changing environment in which would live. Rehnquist, A Notion of Living Constitution, 54 Tex. L. Everett 693, 694, 1976. The task of giving concrete meaning to the term liberty, I have elsewhere explained at some length, was part of the work assigned to future generations. Stevens, The Third Branch of Liberty, 41 U. Miami L. Everett, 277, 291, 1986. Footnote 21. The judge who would outsource the interpretation of liberty to historical sentiment has turned his back on task the Constitution assigned to him and drained the document of its intended vitality. Footnote 22. At this point, difficult question arises in considering such majestic term as a liberty and applying it to present circumstances. How are we to justice to its urgent call and its open texture, and to the grain of interpretive discretion the latter embodies, without injecting excessive subjectivity or unduly restricting the state's broad latitude in experimenting with possible solutions to problems of vital local concern? Whalen v. Roe 429 U. S. 589, 597, 1977. One part of the answer already discussed is that we must ground the analysis in historical experience and reasoned judgment and never on merely personal and private notions. Rochen v. California 342 U. S. 165, 170, 1952. Our precedents place number of additional constraints on the decisional process, although guideposts for responsible decision-making in this uncharted area are scarce and open-ended. Collins v. Harker Heights 503 U. S. 115, 125, 1992. Significant guideposts do exist. Footnote 23. The most basic is that we have eschewed attempts to provide any all-purpose top-down, totalizing theory of liberty. Footnote 24. That project is bound to end in failure or worse. The framers did not express clear understanding of the term to guide us, and the now repudiated Lochner line of cases attests dangers of judicial overconfidence in using substantive due process to advance broad theory of the right or the good. C. E. G. Lochner v. New York 198 U. S. 45, 1905. In its most durable precedents, the court has not attempted to define with exactness the liberty guaranteed by the 14th Amendment, Mayor 262 U. S. at 399. See also E. G. Balling 347 U. S. at 499. By its very nature, the meaning of liberty cannot be reduced to any formula. Its content cannot be determined by reference to any code. Po 367 U. S. that 542. Harlan J. Dissenting. Yet while the liberty specially protected by the 14th Amendment is perhaps not capable of being fully clarified at Glucksberg 521 U. S. at 722, it is capable of being refined and delimited. We have insisted that only certain types of especially significant personal interests may qualify for especially heightened protection. Ever since the deviant economic due process cases were repudiated OD at 761 Souter J. Concurring in judgment, our doctrine has steered away from laws that touch economic problems, business affairs, or social conditions. Griswold 381 U. S. at 482, and has instead centered on matters relating to marriage, procreation, contraception, family relationships, and child rearing and education. Paul v. Davis 424 U. S. 693, 713, 1976. These categories are not exclusive. Government action that shocks the conscience, pointlessly infringes settled expectations, trespasses into sensitive private realms or life choices without adequate justification, perpetrates gross injustice, or simply lacks rational basis will always be vulnerable to judicial invalidation. Nor does the fact that an asserted right falls within of these categories end the inquiry. More fundamental rights may receive more robust judicial protection, but the strength of the individual's liberty interests and the state's regulatory interests must always be assessed and compared. No right is absolute. Rather than seek categorical understanding of the Liberty Clause, our precedents have thus elucidated conceptual core. The clause safeguards most basically the ability independently to define one's identity. Roberts v. Dates J.C.'s 468 U. S. 609, 619, 1984, the individual's right to make certain unusually important decisions that will affect his own or his family's destiny. Fitzgerald 523 F. Twad at 719, and the right to be respected as human being, self-determination, bodily integrity, freedom of conscience, intimate relationships, political equality, dignity, and respect. These are the values we have found implicit in the concept of ordered liberty. Another key constraint on substantive due process analysis is respect for the democratic process. If particular liberty interest is already being given careful consideration in and subjected to ongoing calibration by the states, judicial enforcement may not be appropriate. When the court declined to establish general right to physician-assisted suicide, for example, it did so and because the states were currently engaged in serious, thoughtful examinations of physician-assisted suicide and other similar issues, rendering judicial intervention both less necessary and potentially more disruptive. Glucksberg 521 U.S. at 719-735. Conversely, we have long appreciated that more searching judicial review may be justified when the rights of discrete and insular minorities, groups that may face systematic barriers in the political system, are at stake. United States v. Caroline Products Company 300 4 U.S. 144 153 N 4 1938. Courts have a comparative advantage over the elected branches on limited but significant range of legal matters. Post at 8. Recognizing new liberty right is momentous step. It takes that right to considerable extent outside the arena of public debate and legislative action. Glucksberg 521 U.S. at 720. Sometimes that momentous step must be taken. Some fundamental aspects of personhood, dignity, and the like do not vary from state to state and demand baseline level of protection, but sensitivity to the interaction between the intrinsic aspects of liberty and the practical realities of contemporary society provides an important tool for guiding judicial discretion. This sensitivity is an aspect of deeper principle to approach our work with humility and caution because the relevant constitutional language is so spacious. Duncan 391 U.S. at 148. I have emphasized that the doctrine of judicial self-restraint requires us to exercise the utmost care whenever we are asked to break new ground in this field. Collins 503 U.S. at 125. Many of my colleagues and predecessors have stressed the same point, some with great eloquence. C.E.G. KC 505 U.S. at 849 and more v. East Cleveland 431 U.S. 494 502 503 1977 Plurality Opinion of Poe 367 U.S. at 542 545 Harlan J. Dissenting Adamson v. California 332 U.S. 4668 1947 Frankfurter J. Concurring. Historical study may discipline as well as enrich the analysis, but the inescapable reality is that no serious theory of Section 1 of the 14th Amendment yields clear answers in every case. An O formula could serve as substitute in this area for judgment and restraint. Poe 367 U.S. that 542 Harlan J. Dissenting. Several rules of the judicial process help enforce such restraint. In the substantive due process field, as in others, the court has applied both the doctrine of stare decisis, adhering to precedents, respecting reliance interests, prizing stability and order in the law, and the common law method, taking cases and controversies as they present themselves, proceeding slowly and incrementally building on before. This restrained methodology was evident even in the heyday of the incorporation during the 1960s. Although it would have been much easier for the court simply to declare certain amendments in the Bill of Rights applicable to the states in toto, the court took care to parse each amendment into its component guarantees, evaluating them one by one. This piecemeal approach allowed the court to scrutinize more closely the right at issue in any dispute, reducing both the risk and the cost of error. Relatedly, rather than evaluate liberty claims on an abstract plane, the court has required in substantive due process cases a careful description of the asserted fundamental liberty interest. Glucksberg 521 U.S. at 721, quoting Reno v. Flores 507 U.S. 292, 302, 1993 Collins 503 U.S. at 125 Cruzen v. Director Mo. Department of Health 497 U.S. 261, 277, 278, 1990. And just as we have required such careful description from the litigants, we have required of ourselves that we focus on the allegations in the complaint to determine how petitioner describes the constitutional right at stake. Collins 503 U.S. at 125. See also Stevens Judicial Restraint 22 San Diego L. Everend 437, 446, 448, 1985. This does not mean that we must define the asserted right at the most specific level, thereby sapping it of a universal valence and a moral force it might otherwise have. Footnote 25. It means simply that we must pay close attention to the precise liberty interests the litigants have asked us to vindicate. Our holdings should be similarly tailored. Even if the most expansive formulation of a claim does not qualify for substantive due process recognition, particular components of the claim might, just because there may not be a categorical right to physician-assisted suicide, for example, does not foreclose the possibility that an individual plaintiff seeking to hasten her death or a doctor whose assistance was sought could prevail in more particularized challenge. Glucksberg 521 U.S. at 735 and 24 quoting ID at 750 Stevens J. concurring in judgments. See also Vacco v. Quill 521 U.S. 793, 809, and 13 1997, leaving open the possibility that some applications of the New York prohibition on assisted suicide may impose an intolerable intrusion on the patient's freedom. Even if states' interest in regulating certain matter must be permitted in the general course to trump the individual's countervailing liberty interest, there may still be situations in which the latter is entitled to constitutional protection. Glucksberg 521 U.S. at 742 Stevens J. concurring in judgments. As this discussion reflects, to acknowledge that the task of construing the Liberty Clause requires judgment is not to say that it is license for unbridled judicial lawmaking. To the contrary, only an honest reckoning with our discussion allows for honest argumentation and meaningful accountability. The question in this case, then, is not whether the Second Amendment right to keep and bear arms, whatever that right's precise contours, applies to the states because the amendment has been incorporated into the 14th Amendment. It has not been. The question, rather, is whether the particular right asserted by petitioners applies to the states because of the 14th Amendment itself, standing on its own bottom. And to answer that question, we need to determine, first, in each of the right that has been asserted, and second, whether that right is an aspect of 14th Amendment liberty. Even accepting the court's holding in Heller, it remains entirely possible that the right to keep and bear arms identified in that opinion is not judicially enforceable against the states, or that only part of the right is so enforceable. Footnote 26. It is likewise possible for the court to find in this case that some part of the Heller right applies to the states, and then to find in later cases that other parts of the right also apply, or apply on to terms. As noted at the outset, the liberty interest petitioners have asserted is the right to possess functional personal firearm, including handgun, within the home. Complaint PAP 23. The City of Chicago allows residents to keep functional firearms so long as they are registered, but it generally prohibits the possession of handguns, sawed-off, shotguns, machine guns, and short-barreled rifles. See Chicago Municipal Code SS 2009. Footnote 27. Petitioners' complaint centered on their desire to keep handgun at their domicile. It references the home in nearly every paragraph. See Complaint pp. 4, 11, 30, 32, 34, 37, 42, 44, 46, app. 17, 19, 26, as did their supporting declarations. See E. G. app. 34, 36, 40, 43, 49, 52, 54, 56. Petitioners now frame the question that confronts us as whether the Second Amendment right to keep and bear arms is incorporated as against the states by the 14th Amendment's privileges or immunities or due process clauses. Brief for petitioners P. But it is our duty to focus on the allegations in the complaint to determine how petitioner describes the constitutional right at stake. Collins 503 U.S. 125. And the gravamen of this complaint is plainly an appeal to keep handgun or other firearm of one's choosing in the home. Petitioners' framing of their complaint tracks the court's ruling in Heller. The majority opinion contains some dicta suggesting the possibility of more expansive arms-bearing right, one that would travel with the individual to an extent into public places as in case of confrontation. 554 U.S. at slip-op at 19, but the Heller plaintiff sought only dispensation to keep an operable firearm in his home for lawful self-defense. CID at slip-op at 2 and N2, and the court's opinion was bookended by reminders that its holding was limited to that one issue. ID at slip-op at 164, accord ante at 44, plurality opinion. The distinction between the liberty right these petitioners have asserted and Second Amendment right identified in Heller is therefore evanescent. Both are rooted to the home. Moreover, even if both rights have the logical potential to extend further upon future evaluation, Heller 554 U.S. at slip-op at 63, it is incumbent upon us as federal judges contemplating novel rule that would bind all 50 states to proceed cautiously and to decide only what must be decided. Understood as a plea to keep their preferred type of firearm in the home, petitioner's argument has real force. Footnote 28. The decision to keep loaded handgun in the house is often motivated by the desire to protect life, liberty, and property. It is comparable in some ways to decisions about the education and upbringing of one's children. for it is the kind of decision that may have profound consequences for every member of the family and for the world beyond. In considering whether to keep handgun, heads of households must ask themselves whether the desired safety benefits outweigh the risks of deliberate or accidental misuse that may result in death or serious injury, not only to residents of the home but to others as well. Millions of Americans have answered this question in the affirmative, not infrequently because they believe they have an inalienable right to do so, because they consider it an aspect of the human dignity of being master of one's fate rather than a ward of the state. Indiana v. Edwards, 554 U.S. 164, 186, 2008. Scalia J. Dissenting. Many such decisions have been based, in part, on family traditions and deeply held beliefs that are an aspect of individual autonomy the government may not control. Footnote 29. Bolstering petitioners' claim our law has long recognized that the home provides kind of special sanctuary in modern life. C.E. G.U.S. Const. Ams 3-4 Lawrence 539 U.S. at 562, 567 A Peyton v. New York 445 U.S. 573, 585, 590, 1980 A Stanley v. Georgia 394 U.S. 557, 565, 568, 1969, Griswold 381 U.S. at 484, 485. Consequently, we have long accorded special deference to the privacy of the home, whether humble cottage or magnificent manse. This veneration of the domestic harkens back to the common law. William Blackstone recognized a right of habitation, 4 Commentaries, star 223, and opined that every man's house is looked upon by the law to be his castle of defense and asylum with 3 at star 288. Heller carried forward this legacy, observing that the need for defense of self, family, and property is most acute in one's abode, and celebrating of the right of law-abiding responsible citizens to use arms in defense of hearth and home. 554 U.S. at slip up at 56-63. While the individual's interest in firearm possession is thus heightened in the home, the state's corresponding interest in regulation is somewhat weaker. The state generally has lesser basis for regulating private as compared to public acts, and firearms kept inside the home generally pose lesser threat to public welfare as compared to firearms taken outside. The historical case for regulation is stronger outside the home, as many states have for many years imposed stricter and less controversial restrictions on the carriage of arms than on their domestic possession. C.E. G.I.D. at slip up at 54, noting that the majority of the 19th century courts to consider the question held that prohibitions on carrying concealed weapons were lawful under the Second Amendment or state analogs of the English v. State 35 Tax 173, 478, 479, 1871, observing that almost if not every one of the states of this union have prohibition on the carrying of deadly weapons upon their statute books, and lambasting claims of right to carry such weapons as little short of ridiculous Miller guns as smut, defending the homebound Second Amendment, 109 column L. Everend 1278, 1321, 1336, 2009. It is significant as well that a rule limiting the federal constitutional right to keep and bear arms to the home would be less intrusive on state prerogatives and easier to administer, having unleashed in Heller a tsunami of legal uncertainty and thus litigation. Footnote 30, and now on the cusp of imposing a national rule on the states in this area for the first time in United States history, the court could at least moderate the confusion upheaval burden on the states by adopting a rule that is clearly and tightly bounded in scope. In their briefs to this court, several amici have sought to bolster petitioners' claims still further by invoking right to individual self-defense. Footnote 31, as petitioners note, the Heller majority discussed this subject extensively and remarked that the inherent right of self-defense has been central to the Second Amendment right, 554 U.S. at slip up at 56. And it is true that if state were to try to deprive its residents of any reasonable means of defending themselves from imminent physical threats, or to deny persons any ability to assert self-defense in response to criminal prosecution, that might pose significant constitutional problem. The argument that there is substantive due process right to be spared such untenable dilemmas is serious one. Footnote 32, but not the case before us. Petitioners have not asked that we establish constitutional right to individual self-defense, and neither their pleadings in the district court nor their filings in this court make any such request, nor do petitioners contend that the city of Chicago, which, recall, allows its residents to keep most rifles and shotguns, and to keep them loaded, has unduly burdened any such right. What petitioners have asked is that we incorporate the Second Amendment and thereby establish constitutional entitlement enforceable against estates to keep handgun in the home. Of course, owning handgun may be useful for practicing self-defense, but the right to take certain type of action is analytically distinct from the right to acquire and utilize specific instrumentalities in furtherance of that action. And while some might favor handguns, it is not that they are superior weapon for lawful self-defense, and nothing in petitioner's argument turns on that being the case. The notion that right of self-defense implies an auxiliary right to own certain type of firearm presupposes not only controversial judgments about the strength and scope of the posited self-defense right, but also controversial assumptions about the likely effects of making that type of firearm more broadly available. It is very away from the proposition that the 14th Amendment protects basic individual right of self-defense to the conclusion that city may not ban handguns. Footnote 33, in short, while the utility of firearms, and handguns in particular, to the defense of hearth and home is certainly relevant to an assessment of petitioner's asserted right, there is no freestanding self-defense claim in this case. The question we must decide is whether the interest in keeping in the firearm of one's choosing, a handgun for petitioners, is one that is comprised within the term liberty in the 14th Amendment, Whitney 274 U.S. at 373 Brandeis, J. concurring. While I agree with the court that our substantive due process cases offer a principled basis for holding that petitioners have a constitutional right to possess a usable firearm in the home, I am ultimately persuaded that a better reading of our case law supports the city of Chicago. I would not foreclose the possibility that a particular plaintiff, say, an elderly widow who lives in a dangerous neighborhood and does not have the strength to operate a long gun, may have a cognizable liberty interest in possessing a handgun. But I cannot accept petitioner's broader submission. Number of factors taken together lead me to this conclusion. First, firearms have fundamentally ambivalent relationship to liberty. Just as they can help homeowners to their families and property from intruders, they can help thugs and insurrectionists murder innocent victims. The threat that firearms will be misused is far from hypothetical, for gun crime has devastated many of our communities. MSI calculate that approximately 1 million Americans have been wounded or killed by gunfire in the last decade. Footnote 34. Urban areas such as Chicago suffer disproportionately from this epidemic of violence. Handguns contribute disproportionately to it. Just as some homeowners may prefer handguns because of their small size, lightweight, and ease of operation, some criminals will value them for the same reasons. C. Heller 550 U.S. at Breyer J. Dissenting slip-op at 3233. In recent years, handguns were reportedly used in more than 4/5 of firearm murders and more than half of all murders nationwide. Footnote 35. Hence, in evaluating an asserted right to be free from particular gun control regulations, liberty is on both sides of the equation. Guns may be useful for self-defense as well as for hunting and sport, but they also have a unique potential to facilitate death and destruction and thereby to destabilize ordered liberty. Your interest in keeping and bearing a certain firearm may diminish my interest in being and feeling safe from armed violence. And while granting you the right to own a handgun might make you safer on any given day, assuming the handgun's marginal contribution, self-defense outweighs its marginal contribution to the risk of accident, suicide, and criminal mischief, it may make you and the community you live in less safe overall, owing to the increased number of handguns in circulation. It is at least reasonable for democratically elected legislature to take such concerns into account in considering what sorts of regulations would best serve the public welfare. The practical impact of various gun control measures be highly controversial, but this basic insight should not be the idea that deadly weapons pose distinctive threat to the social order and that reasonable restrictions on their usage therefore impose an acceptable burden on one's personal liberty. Is as old as the Republic. As the Chief Justice observed just the other day, it is foundational premise of modern government that the state holds monopoly on legitimate violence. Basic step in civilized society is to take the sword out of private hands and turn it over to an organized government, acting on behalf of all the people. Robertson v. United States ex rel. Watson ante et slip-op at 11, dissenting opinion. The same holds true for the handgun. The power a man has in the state of nature of doing whatsoever he thought fit for the preservation of himself and the rest of mankind he gives up to significant extent to be regulated by laws made by the society. J. Locke, Second Treatise of Civil Government, SSP 64J, Go ed. 1947. Limiting the federal constitutional right to keep and bear arms to the home complicates the analysis but does not dislodge. Conclusion. Even though the court has long afforded special solicitude for the privacy of the home, we have never understood that principle to infringe upon the authority of the states to prescribe certain inherently dangerous items, for in such cases, compelling reasons may exist for overriding the right of the individual to possess those materials. Stanley 394 U.S. at 568 and 11. And of course, guns that start out in the home may not stay in the home. Even if the government has weaker basis for restricting domestic possession of firearms as compared to public carriage, and even if blanket, statewide prohibition on domestic possession might therefore be unconstitutional. The line between the two is porous. One state or local legislature may determine that prophylactic ban on an especially portable weapon is necessary to police that line. Second, the right to possess firearm of one's choosing is different from the liberty interests we have recognized under the Due Process Clause. Despite the plethora of substantive due process cases that have been decided in the post-Lochner century, I have found none that holds states or even suggests that the term liberty encompasses either the common law right of self-defense or right to keep and bear arms. I do not doubt for a moment that many Americans feel deeply passionate about firearms and see them as critical to their way of life as well as to their security. Nevertheless, it does not appear to be the case that the ability to own a handgun or any particular type of firearm is critical to leading a life of autonomy, dignity, or political equality. The marketplace offers many tools for self-defense, even if they are imperfect substitutes and need. Petitioners nor their amici make such a contention. Petitioners' claim is not the kind of substantive interest, accordingly, on which uniform, judicially enforced national standard is presumptively appropriate. Footnote 36. Indeed, in some respects the substantive right at issue may be better viewed as property right. Petitioners wish to acquire certain types of firearms or to keep certain firearms they have previously acquired. Interests in the possession of chattels have traditionally been viewed as property interests, subject to definition and regulation by the states. Cf. Stop the Beach Renourishment, Inc. v. Florida, Department of Environmental Protection, 560 U.S. 2010, Slip-Op at 1 Opinion of Scalia J. Generally speaking, state law defines property interests. Under that tradition, Chicago's ordinance is unexceptional. Footnote 37. The liberty interest asserted by petitioners is also dissimilar from those we have recognized in its capacity to undermine the security of others. To be sure, some of the Bill of Rights procedural guarantees may place restrictions on law enforcement that have controversial public safety implications. Ante at 36, plurality opinion. See also ante at 9, opinion of Scalia J. But those implications are generally quite attenuated. A defendant's invocation of his right to remain silent, to confront witness, or to exclude certain evidence cannot directly cause any threat. The defendant's liberty interest is constrained by, and is itself constrained on, the adjudicatory process. The link between handgun ownership and public safety is much tighter. The handgun is itself tool for crime. The handgun's bullets are the violence. Similarly, it is undeniable that some may take profound offense. Remark made by the soapbox speaker: the practices of another religion or gay couple's choice to have intimate relations, but that offense is moral, psychological, or theological in nature. The actions taken by the rights bearers do not actually threaten the physical safety of any other person. Footnote 30. Firearms may be used to kill another person. If legislature's response to dangerous weapons ends up impinging upon the liberty of any individual in pursuit of the greater good, it invariably does so on the basis of more than the majority's own moral code. Lawrence 539 U.S. at 571, quoting KC 505 U.S. at 850. While specific policies may of course be misguided, gun control is an area in which it is quite wrong to assume that regulation and liberty occupy mutually exclusive zones. That as one expands, the other must contract. Stevens 41 U. Miami L. Everend at 280. Third, the experience of other advanced democracies, including those that share British heritage, undercuts the notion that an expansive right to keep and bear arms is intrinsic to ordered liberty. Many of these countries place restrictions on the possession, use, and carriage of firearms far more onerous than the restrictions found in this nation. See Municipal Respondents Brief 2123, discussing laws of England, Canada, Australia, Japan, Denmark, Finland, Luxembourg, and New Zealand. That the United States is an international outlier in the permissiveness of its approach to guns does not suggest that our laws are bad laws. It does suggest that this court may not need to assume responsibility for making our laws still more permissive. Admittedly, these other countries differ from ours in many relevant respects, including their problems with violent crime and the traditional role that firearms have played in their societies, but they are not so different from the United States that we ought to dismiss their experience entirely. Cf. Ante at 3435, Plurality Opinion, Ante at 1011, Opinion of Scalia J. The fact that our oldest allies have almost uniformly found it appropriate to regulate firearms extensively tends to weaken petitioner submission that the right to possess gun of one's choosing is fundamental to life of liberty. While the American perspective must always be our focus, Ante at 3744, Plurality Opinion, indeed the arrogant, to think we have nothing to learn about liberty from the billions of people beyond our borders. Fourth, the Second Amendment differs in kind from the amendments that surround it, with the consequence that its inclusion in the Bill of Rights is not merely unhelpful but positively harmful to petitioners' claim. Generally, the inclusion of liberty interest in the Bill of Rights points toward the conclusion that it is of fundamental significance and enforceable against the states. But the Second Amendment plays a peculiar role within the bill as announced by its peculiar opening clause. Footnote 39. Even accepting the Heller Court's view that the amendment protects an individual right to keep and bear arms disconnected from militia service, it remains undeniable that the purpose for which the right was codified was to prevent elimination of the militia. Heller, 554 U.S. at Slip-Op, at 26. See also United States v. Miller, 307 U.S. 174-178, 1939. Second Amendment was enacted. With obvious purpose to assure the continuation and render possible the effectiveness of militia forces. It was the states, not private persons, on whose immediate behalf the Second Amendment was adopted. Notwithstanding the Heller Court's efforts to write the Second Amendment's preamble out of the Constitution, the amendment still serves the structural function of protecting the states from encroachment by an overreaching federal government. The Second Amendment, in other words, is federalism. Provision, Elk Grove Unified School Dist. v. Newdow 542 U.S. 145, 2004, Thomas J. Concurring in judgment. It is directed at preserving the autonomy of the sovereign states, and its logic, therefore, resists incorporation by a federal court against the states. No one suggests that the 10th Amendment, which provides that powers not given to the federal government remain with the states, that applies to the states. Such reading would border on incoherent, given that the 10th Amendment exists in significant part to safeguard the vitality of state governance. The Second Amendment is no different. Footnote 40. The Court is surely correct that Americans' conceptions of the Second Amendment right evolved over time in more individualistic direction, that members of the Reconstruction Congress were urgently concerned about the safety of the newly freed slaves, and that some members believed that, following ratification of the 14th Amendment, the Second Amendment would apply to the states, but it is a giant leap from. Data points to the conclusion that the 14th Amendment incorporated the Second Amendment as matter of original meaning or post-enactment interpretation. Consider, for example, that the text of the 14th Amendment says nothing about the Second Amendment or firearms, that there is substantial evidence to suggest that, when the Reconstruction Congress enacted measures to ensure newly freed slaves and Union sympathizers in the South enjoyed the right to firearms, it was motivated by anti-discrimination and equality concerns rather than arms-bearing concerns per se. Footnote 41. At many contemporaneous courts and commentators did not understand the 14th Amendment to have had an incorporating an effect in that the states heavily regulated the right to keep and bear arms both before and after the amendment's passage. The court's narrative largely elides these facts. The complications raised show why even the most dogged historical inquiry into the fundamentality of the Second Amendment right or any other necessarily entails judicial judgment, and therefore judicial discretion, every step of the way. I accept that the evolution in Americans' understanding of the Second Amendment may help shed light on the question whether right to keep and bear arms is comprised within 14th Amendment liberty, but the reasons that motivated the framers to protect the ability of militiamen to keep muskets available for military use when our nation was in its infancy, or that motivated the Reconstruction Congress to extend full citizenship to the freedmen in the Civil War, have only limited bearing on the question that confronts the homeowner and crime-infested metropolis today. The many episodes of brutal violence against African Americans that blight our nation's history, see Ante at 2329, Majority Opinion, Ante at 4144, 5355, Thomas J. Concurring in part and concurring in judgment, do not suggest that every American must be allowed to whatever type of firearm he or she desires just that no group of Americans should be systematically and discriminatorily disarmed and left to the mercy of racial terrorists. And the fact that some Americans may have thought or hoped that the 14th Amendment would nationalize the Second Amendment hardly suffices to justify the conclusion that it did. Fifth, although it may be true that Americans' interest in firearm possession and state law recognition of interest are deeply rooted in some important senses at 19 internal quotation marks omitted, it is equally true that the states have long an unbroken history of regulating firearms. The idea that states may place substantial restrictions on the right to keep and bear arms short of complete disarmament is, in fact, far more entrenched than the notion that the federal Constitution protects any such right. Federalism is a far older and more deeply rooted tradition than his right to carry or to own any particular kind of weapon. 567 F. 3 856 860 Ca 2009 Easterbrook C. Day. From the early days of the Republic through the Reconstruction era to the present day, states and municipalities have placed extensive licensing requirements on firearm acquisition, restricted public carriage of weapons, and banned altogether the possession of especially dangerous weapons, including handguns. See Heller 554 U.S. at Brer J. Dissenting Slip-Op F47 Reviewing Colonial Laws of Cornell and Dedina Well-Regulated Right. The Early American Origins of Gun Control 73 Ford ML. Everend 487, 502 516 2004 Reviewing Pre-Civil War Laws, a brief for 34 professional historians and legal historians as Amici Curie 422 Reviewing Reconstruction Era Laws, Winkler Scrutinizing the Second Amendment, 105 Mitch, Everend 683, 711 712, 716 726 2007 Reviewing 20th Century Laws, see Generally Post at 2131. Footnote 42. After the 1860s, just as before, the state courts almost uniformly upheld these measures. Apart from making clear that all regulations had to be constructed and applied in non-discriminate manner, the 14th Amendment hardly made that. And let us not forget that this court did not recognize any non-militia-related interests under the Second Amendment until 2 terms ago in Heller. Petitioners do not dispute the City of Chicago's observation that no other substantive Bill of Rights protection has been regulated nearly as intrusively as the right to keep and bear arms. Municipal Respondents, Brief 25. Footnote 43. This history of intrusive regulation is not surprising given that the very text of the Second Amendment calls out for regulation, footnote 44, and the ability to respond to the social ills associated with dangerous weapons goes to the very core of the state's police powers. Our precedent is crystal clear on this latter point. C. A. G. Gonzalez v. Oregon 546 U.S. 243 270 2006 T. He structure and limitations of federalism allow the states great latitude under their police powers to legislate as to the protection of the lives, limbs, health, comfort, and quiet of all persons. Internal quotation marks omitted. United States v. Morrison 529 U.S. 598 618 2000 W.E. can think of no better example of the police power which the founders denied the national government and reposed in the states than the suppression of violent crime and vindication of its victims. Kelly v. Johnson 425 U.S. 238 247 1976. The promotion of safety of persons and property is unquestionably at the core of the state's police power. Automobile Workers v. Wisconsin Employment Relations BD 351 U.S. 266 274 1956. The dominant interest of the state in preventing violence and property damage cannot be questioned. It is matter of genuine local concern. Compared with today's ruling, most, if not all, of this court's decisions requiring the states to comply with other provisions in the Bill of Rights did not exact nearly so heavy toll in terms of state sovereignty. Finally, even apart from states' long history of firearms regulation and its location at the core of their police powers, this is quintessential area in which federalism ought to be allowed to flourish without this court's meddling. Whether or not we can assert a plausible constitutional basis for intervening, there are powerful reasons why we should not do so. Across the nation, states and localities vary significantly in the patterns and problems of gun violence they face as well as in the traditions and cultures of lawful gun use they claim. Cf. Post at 1617. The city of Chicago, for example, faces a pressing challenge in combating criminal street gangs. Rural areas do not. The city of Chicago has a high population density, which increases the potential for a gunman to inflict mass terror and casualties. Most rural areas do not. Footnote 45. The city of Chicago offers little in the way of hunting opportunities. Residents of rural communities are, one presumes, much more likely to stock the dinner table with game they have personally felled. Given that relevant background conditions diverge so across jurisdictions, the court ought to pay particular heed to state and local legislatures, bright to experiment. New State Ice 285 U.S. The 311 Brandeis J. Dissenting, so long as the regulatory measures they have chosen are not arbitrary, capricious, or unreasonable, we should be allowing them to try novel social and economic policies. IVD is more in keeping with our status as court in federal system under these circumstances to avoid imposing single solution from the top down. Smith v. Robbins 528 U.S. 259, 275, 2000. It is all the more unwise for this court to limit experimentation in an area where the best solution is far from clear. United States v. Lopez 514 U.S. 549, 581, 1995. Kennedy, J. Concurring. Few issues of public policy are subject to such intensive and rapidly developing empirical controversy as gun control. See Heller, 554 U.S. at Slip Op, at 2025, Breyer J. Dissenting. Chicago's handgun ban in itself has divided researchers. Compare brief for professors of criminal justice as amici curiae arguing that ordinance has been effective at reducing gun violence with brief for International Law Enforcement Educators and Trainers Association et al. As amici curiae 1726 arguing that ordinance has been failure. Footnote 46. Course on some matters the Constitution requires that we ignore such pragmatic considerations, but the Constitution's text, history, and structure are not so clear on the matter before us, as evidenced by the groundbreaking nature of today's fractured decision, and this court lacks both the technical capacity and the localized expertise to assess the wisdom and propriety of most gun control measures. Griswold, 381 U.S. at 482. Footnote 47. Nor will the court's intervention bring any clarity to this enormously complex area of law. Quite to the contrary, today's decision invites an avalanche of litigation that could mire the federal courts in fine-grained determinations about which state and local regulations comport with the Hellerite, the precise contours of which are far from pellucid. Under standard of review, we have not even established. See post at 1215, the pluralities. The assurance at incorporation does not imperil every law regulating firearms, so ante at 40 provides only modest comfort. For it is also an admission of just how many different types of regulations are potentially implicated by today's ruling and of just how ad hoc the court's initial attempt to draw distinctions among them was in Heller. The practical significance of the proposition that the Second Amendment right is fully applicable to the states the ante at one majority opinion remains to be worked out by this court over many, many years. Furthermore, and critically, the court's imposition of national standard is still more unwise because the elected branches have shown themselves to be perfectly capable of safeguarding the interest in keeping and bearing arms. The strength of liberty claim must be assessed in connection with its status in the democratic process, and in this case, no one disputes that opponents of gun control have considerable political power and do not seem to be at systematic disadvantage in the democratic process, or that the widespread commitment to an individual right to own guns operates as safeguard against excessive or unjustified gun control laws. Footnote 48. Sunstein, Second Amendment Minimalism. Heller as Griswold, 122 Harv. L. Everend 246, 260, 2008. Indeed, there is a good deal of evidence to suggest that, if anything, American lawmakers tend to underregulate guns relative to the policy views expressed by majorities in opinion polls. C.K. Goss Disarmed. The Missing Movement for Gun Control in America 6, 2006. If particular state or locality has enacted some improvident gun control measures as petitioners believe Chicago has done, there is no apparent reason to infer that mistake will not eventually be rectified by the democratic process. Vance v. Bradley 440 U.S. 93, 97, 1979. This is not case then that involves special condition at may call for correspondingly more searching judicial inquiry. Caroline Products 304 U.S. at 153 N. 4. Neither petitioners nor those most zealously committed to their views represent a group or a claim that is liable to receive unfair treatment at the hands of the majority. On the contrary, petitioners' views are supported by powerful participants in the legislative process. Petitioners have given us no reason to believe that the interest in keeping and bearing arms entails any special need for judicial lawmaking, or that federal judges are more qualified to craft appropriate rules than the people's elected representatives. Having failed to show why their asserted interest is intrinsic to the concept of ordered liberty or vulnerable to maltreatment in the political arena, they have failed to show why the word liberty in the 14th Amendment should be held to prevent the natural outcome of dominant opinion about how to deal with the problem of handgun violence in the city of Chicago. Lochner, 198 U.S. at 76 Holmes J. Dissenting. The preceding sections have already addressed many of the points made by Justice Scalia in his concurrence, but in light of that opinion's fixation on this one, it is appropriate to say a few words about Justice Scalia's broader claim. That is, preferred method of substantive due process analysis method, that makes the traditions of our people paramount ante at one is both more restrained and more facilitative democracy than the method I have outlined. Colorful as it is, Justice Scalia's critique does not have nearly as much force as does his rhetoric. His theory of substantive due process, moreover, comes with its own profound difficulties. Although Justice Scalia aspires to an objective, a neutral method of substantive due process analysis ante at 10, his actual method is nothing of the sort. Under the historically focused approach he advocates ante at 13, numerous threshold questions arise before one ever gets to the history. At what level of generality should one frame the liberty interest in question? CN 25 Super. What does it mean for right to be deeply rooted in this nation's history and tradition? Ante at 3, quoting Glucksberg 521 U.S. at 721. By what standard will that proposition be tested? Which types of sources will count, and how will those sources be weighed and aggregated? There is no objective, neutral answer to these questions. There is not even theory, at least. Justice Scalia provides none of how to go about answering them, nor is there any escaping palco, it seems. To qualify for substantive due process protection, Justice Scalia has stated, an asserted liberty right must be not only deeply rooted in American tradition, but it must also be implicit in the concept of ordered liberty. Lawrence 539 U.S. at 593 and 3 dissenting opinion, internal quotation marks omitted. Applying the latter palco derived to half of that test requires precisely the sort of reasoned judgment, the same multifaceted evaluation of the right's contours and consequences that Justice Scalia mocks in his concurrence today. So does applying the first half. It is hardly novel insight that history is not an objective science and that its use can point in any direction the judge's favor. Ante at 14, opinion of Scalia J. Yet 21 years after the point was brought to his attention by Justice Brennan, Justice Scalia remains oblivious to the fact that the concept of a tradition can be as malleable and elusive as liberty itself. Michael H. 491 U.S. at 137, dissenting opinion. Even when historical analysis is focused on a discrete proposition, such as the original public meaning of the Second Amendment, the evidence often points in different directions. The historian must choose which pieces to credit and which to discount, and then must try to assemble them into a coherent whole. In Heller, Justice Scalia preferred to rely on sources created much earlier and later in time than the Second Amendment itself. C.E.G. 154 U.S. at Slip-Op at 4.5, consulting late 19th century treatises to ascertain how Americans would have read the amendment's preamble in 1791. I focused more closely on sources contemporaneous with the amendment's drafting and ratification. Footnote 49. No mechanical yardstick can measure which of us was correct, either with respect to the materials we chose to privilege or the insights we gleaned from them. The malleability, elusiveness of history increase exponentially when we move from pure question of original meaning, as in Heller, to Justice Scalia's theory of substantive due process. At least with the former sort of question, the judge can focus on single legal provision if the temporal scope of the inquiry is or should be relatively bounded, and there is substantial agreement on what sorts of authorities merit consideration. With Justice Scalia's approach to substantive process, these guideposts all fall away. The judge must canvass the entire landscape of American law as it has evolved through time, and perhaps older laws as well. C.E.G. Lawrence 539 U.S. at 596 Scalia J. Dissenting, discussing ancient roots of prescriptions against sodomy, quoting Bowers v. Hardwick 478 U.S. 186, 192, 1986, pursuant to standard deeply rootedness that has never been defined. In conducting this rudderless panoramic tour of American legal history, the judge has more than ample opportunity to Look over the heads of the crowd and pick out his friends. Roper v. Simmons 543 U.S. 551 617 2005 Scalia J. Dissenting. My point is not to criticize judges' use of history in general or to suggest that it always generates indeterminate answers. I have already emphasized that historical study can discipline as well as enrich substantive due process analysis. My point is simply that Justice Scalia's defense of his method, which holds out objectivity and restraint as its cardinal, and it seems only virtues, is unsatisfying on its own terms, for limitless number of subjective judgments may be smuggled into his historical analysis. Worse, they may be buried in the analysis. With my approach, the judge's cards are laid on the table for all to see and to critique. The judge must exercise judgment, to be sure. When answering constitutional question to which the text provides no clear answer, there is always some amount of discretion. Our constitutional system has always depended on judges filling in the documents, vast open spaces. Footnote 50. But there is also transparency. Justice Scalia's approach is even less restrained in another sense. It would affect major break from our case law outside of the incorporation area. Justice Scalia does not seem troubled by the fact that his method is largely inconsistent with the court's canonical substantive due process decision, ranging from Mayer 262 U.S. 390 and Pierce 268 U.S. 510 in the 1920s to Griswold 381 U.S. 479 in the 1960s to Lawrence 539 U.S. 558 in the 2000s. To the contrary, he seems to embrace this dissonance. My method seeks to synthesize dozens of cases on which the American people have relied for decades. Justice Scalia's method seeks to vaporize them. So I am left to wonder which of us is more faithful to this nation's constitutional history and which of us is more faithful to the values and commitments of the American people as they stand today. In 1967, when the court held in Loving 388 U.S. 1 that adults have liberty-based as well as equality-based right to wed persons of another race, interracial marriage was hardly deeply rooted in American tradition. Racial segregation and subordination were deeply rooted. The court's substantive due process holding was nonetheless correct, and we should be wary of any interpretive theory that implies emphatically that it was not. Which leads me to the final set of points I wish to make. Scalia's method invites not only bad history but also bad constitutional law. As I have already explained, in evaluating claim, liberty interest, or any constitutional claim for that matter, it makes perfect sense to give history significant weight. Justice Scalia's position is closer to my own than he apparently feels comfortable acknowledging, but it makes little sense to give history dispositive weight in every case, and it makes especially sense to answer questions like whether the right to bear arms is a fundamental by focusing only on the past, given that both the practical significance and the public understandings of such right often change as society changes. What if the evidence had shown that, whereas at one time firearm possession contributed substantially to personal liberty and safety, nowadays it contributes nothing or even tends to undermine them? Would it still have been reasonable to constitutionalize the right? My concern runs still deeper. Not only can historical views be less than completely clear or informative, but they can also be wrong. Some notions that many Americans deeply believe to be true at one time turned out not to be true. Some practices that many Americans believe to be consistent with the Constitution's guarantees of liberty and equality at one time turned out to be inconsistent with them. The fact that we have written Constitution consign this nation to static legal existence, although we should always why decent regard to the opinions of former times. It is not the glory of the people of America to have suffered blind veneration for antiquity. Of the Federalist No. 14p. 99, 104c, Rossiter ed. 1961 J. Madison. It is not the role of federal judges to be amateur historians, and it is not fidelity to the Constitution to ignore its use of deliberately capacious language in an effort to transform foundational legal commitments into narrow rules of decision. As for the democratic process, the at 1415 method that looks exclusively to history can easily do more harm than good. Just consider this case. The net result of Justice Scalia's supposedly objective analysis is to vest federal judges, ultimately majority of the judges on this court, with unprecedented lawmaking powers in an area in which they have no special qualifications and in which the give and take of the political process has functioned effectively for decades. Why this intrudes much less upon the democratic process than at 14 than an approach that would defer to the democratic process on the regulation of firearms is, to say the least, not self-evident. I cannot even tell what, under Justice Scalia's view, constitutes an intrusion. It is worth pondering, furthermore, the vision of democracy that underlies Justice Scalia's critique, because very few of us would welcome a system in which majorities or powerful interest groups always get their way. Under our constitutional scheme, I would have thought that judicial approach to liberty claims such as the one I have outlined, an approach that investigates both the intrinsic nature of the claimed interest and the practical significance of its judicial enforcement, that is transparent in its reasoning and sincere in its effort to incorporate constraints, that is guided by history but not beholden to it, and that is willing to protect some rights even if they already received uniform protection from the elected branches, has the capacity to improve rather than imperil ante at 15 our democracy. It all depends on judges exercising careful, reasoned judgment, as it always has and as it always will. The fact that the right to keep and bear arms appears in the Constitution should not obscure the novelty of the court's decision to enforce that right against the states. By its terms, the Second Amendment does not apply to the states. Read properly, it does not even apply to individuals outside of the militia context. The Second Amendment was adopted to protect the states from federal encroachment, and the 14th Amendment has never been understood by the court to have incorporated the entire Bill of Rights. There was nothing foreordained about today's outcome. Although the court's decision in this case might be seen as mere adjunct to its decision in Heller, the consequences could prove far more destructive, quite literally, to our nation's communities and to our constitutional structure. Thankfully, the Second Amendment right identified in Heller and its newly minted 14th Amendment analog are limited, at least for now, to the home. But neither the assurances provided by the plurality ante at 40 nor many historical sources cited in its opinion should obscure the reality that today's ruling marks dramatic change in our law, or that the justices who have joined it have brought to bear an awesome amount of discretion in resolving the legal question presented by this case. I will proceed more cautiously. For the reasons set out at length above, I cannot accept either the methodology the court employs or the conclusions it draws, although impressively argued. The majority's decision to overturn more than a century of Supreme Court precedent and unsettle much longer tradition of state practice is not, in my judgment, built upon respect for the teachings of history, solid recognition of the basic values that underlie society, and wise appreciation of the great roles that the doctrines of federalism and separation of powers have played in establishing and preserving American freedoms. Griswold, 381 U.S. at 501 Harlan J. Concurring in judgment. Accordingly, I respectfully dissent.